Hello and welcome. Today I'm going to discuss preparation for both those facing state and federal charges. Hi, my name is Marc Blatstein, the founder of Physician Pre-Sentence Report Service. I too was convicted of a felony in 2006 on the federal side, and I was totally unprepared for everything, both legal and prison related. I probably wasn't the best client because I wasn't being candid with counsel or my own attorneys or myself. After failed appeals, I was released, and with the support of colleagues and friends, my medical license was reinstated in 2010. But I digress. What I'm going to review comes from lessons learned, and I'm going to add in a client example to demonstrate this. The first part is, and whether most of this, while I'm not directly familiar with state charges, I believe that there are some common themes, if you will. And so one of them is going to be that you should probably interview an attorney if you're in a position to do so. On the federal side, you want to know someone you want to know that it's a good fit for both you, or on the state side, the same thing. If they practice federal criminal defense in federal court, or if they practice state defense, if you're on the state side, in your particular court. You want to know if they have experience with cases similar to yours. You probably want to go ahead. It would be smart to check with your state bar and see whether it doesn't matter if they're state or federal case, if there are any disciplinary problems there. Then you want to ask them if they have you want to see if there's a proven track record of handling cases like yours, specifically if they're willing to provide several past clients for you to speak with to ease some of your concerns, because this is probably not the highlight of your life. Then there's something called a sentencing memorandum. And this is something that your attorney, 1 to 2 weeks, about 10 days before sentencing turns in, but you want to be able to read at least 2, 3, or 4 different sentencing memorandums. And if the attorney brings up HIPAA, which is a privacy act, that's true. But with Adobe, your attorney is actually able to redact all personal information. Additionally, if you're paying for these services, you want to know if the fees are flat fees, or if they're hourly, if there's some sort of payment schedule. Again, you want to make sure that you're comfortable with this particular attorney. And if you want to go to trial, you may feel that you're innocent, and at times you probably may be. Just because you're feeling right is not sufficient. I mean, I give you Sam Bankman-Fried and Elizabeth Holmes. They fought tooth and nail, didn't do any good. And on the federal side, I can't speak to the state side, the Department of Justice has a 98% conviction rate. So by the time you as an individual learn that they've been asking questions, you know, chances are they have most of their case already against you nailed up pretty tight. Additional strategic questions is going to be then that will rise out of that conversation is how many trials and or appeals have they won, or what percentage have they won over the past, let's say, 5 years, 3 to 7 years? Because if you're going to go to trial, you want to know if they've won any cases, especially on the federal side. Not many people win, but it comes down to, to your case, to the facts, what you and your attorney decide. And even if you go to trial and you lose, all's not lost. You still have, you still have options. But what you do not want to do is you don't want to anger the court. Again, I'll go back to Sam Bankman-Fried. You don't want to be like him in FTX. You don't want to have any witness tampering. You don't want to increase or get the court or get the judge anger with you just because, in addition to losing, this is playing Russian roulette with your life. At least you lose at trial, you still can go back, into court before sentencing and ask for leniency, ask for mercy. When you're speaking to your attorney, understand that whether it's state or federal, that a single attorney in a practice can maybe support 2 or 3 criminal charges. That means those that go full out towards trial a year. And so it depends how busy they are. Can they handle you as another case, whether it's state or federal? And if they say yes, then will you be dealing with partner attorneys, paralegals, or the secretaries? And so it's very important to know that you just don't want to pick any attorney. I mean, I've had a client in the past that he came to me 5 years after dealing with this one attorney, and it only took me a couple of minutes of Googling that this attorney may have taken a federal case, which he was, but he was a personal injury lawyer. And so I don't know what business he had. I don't even know why the client that became mine stuck with him, but it was at his peril. So to continue, you've been indicted. After that, you just don't want to sit on your laurels. You need to begin advocating yourself, because if you do nothing, it's at your peril. As I said, on the federal side, and I would assume on the state side, pretty much their cases are pretty they're pretty tight. The conviction rate, as I said, on the federal side is 98%. So take it from there. Your attorney knows all of the legal stuff. You can't be expected to know that. They are going to go out of their way to connect with your probation officer who writes the pre-sentence report, because they are overworked, have no time, and will appreciate any effort that your legal team and you will do to make their workload a little bit easier. In addition, there's the pre-sentence report that whatever your attorney is going to have to learn, what date are they going to do the pre-sentence interview, and what date is the final dictation date for the probation officer to have their pre-sentence report done. Above that, the probation officers who conduct the pre-sentence interview and investigation, they can make a placement recommendation to the judge. That's a big deal, because they become now probably the most important person in your life that you have to influence in your behalf. And so how do you do this? You don't want to wait around while your lawyer's doing legal things. You should be taking time to think about your narrative. You have your indictment out there. The indictment is your story that was released by the prosecutor at the state level, the Department of Justice, or the federal lawyer, and that's their story of you. And it probably does not paint a very flattering picture. And so that by you writing your narrative, which is your story, will, as you write it, you need to keep in mind of how the judge and the probation officer will perceive you. So you're accepting responsibility, but the judge and the probation officer, they want to know why you did what you did. What happened in your life? This is your life story. It contains all of the good things that happened to you in life, the bad things that happened to you in life. It explains everything in your indictment without any excuses. You're not making any excuses at all. You have victims. And so, you have to acknowledge responsibility for the harm that you inflicted on your victims, even if it states in some types of crimes that there were no victims per se. Every charge or crime has a victim. And so if you are having trouble there, please feel free to reach out to me or someone else who understands this, understands this part of the law. You want to express remorse, and hopefully you can begin to synthesize a plan of possibly how you can change your life. Maybe it's before if you anticipate you'll be going to prison. And on the federal side, only 2% or less than 2% do not go. And so you want to be able to share that that you'll be incarcerated, and that you owe it to the victims and to the court, to your family, to come out of the other end as a different person. This is your opportunity to humanize yourself to the probation officer, most important, and then the judge. And while it seems premature to address the release plan at this juncture, judges want to know that they don't want to see you again in their courtroom. And so they may ask you in some form, what do you have to say? This is called the allocution. It's the conversation between you and your judge. And with a well-written narrative that can be 20 pages, it can be in a video format that is under 10 minutes. You can explain without excuses what brought you to this point in your life. And at the same time, answering your judge's questions as to why you won't be back in the courtroom, that you have remorse for those that you have victimized, and that in your release plan, whether you have letters regarding your character that will support you once you get out, and they will hold you accountable so that you don't get back in trouble, which is a good letter from people that have known you for a long time, or maybe someone's willing to hire you when you get out. All of those are good letters. But if you delay until the day of sentencing, this is at your peril, because, as I said, on the federal side, 90%, 98% are convicted and go to prison. And on the state side, I don't know the percentage, but the common thread here is that judges, state or federal, want to know what made you do what you did, and do you have remorse for your actions? Do you understand that there were victims? And do you accept responsibility? Now, these are very short phrases, but the conversation opens up a very deep, well written narrative that is your life story. So have you been preparing all along since the day of your indictment? Because you need to think, what does the judge want to hear after you've written your story without an excuse? What do they want to know? And a well-written narrative is your story. What does the judge want to hear? That you have victims and you accept responsibility for harming them. You have remorse. You have a release plan. You have prepared everything for the interview and provided it to your probation officer 1 to 2 weeks before your interview. Hopefully, the answer is yes. In other words, all the information that the probation officer needs should be provided to them 1 to 2 weeks before the interview. And that will include your narrative that's been well written and hopefully reviewed by someone who doesn't want to enable you, but will read the narrative critically and tell you if it sounds good or not. Release plan the same way. And the allocution would be your part of the conversation with the court where that, you realize that you really screwed up and that, if you had it to do over again, there are no redos, but that you just can't live with yourself to have to go through this another time and put your family or victims through this ever again. Then 30 days before sentencing, you want to review your pre-sentence report for accuracy. If in fact there were drugs involved or alcohol involved in the charge, or within, at least if it was a problem, within the 12 months prior to your arrest, and it's part of the pre-sentence report, which is your responsibility and then your attorney's responsibility. It should be in the report. Well, you need to read the pre-sentence report before sentencing and make sure it's in that also. And then you want to have practice your allocution with someone. You don't want to go in and do it, cold that day. If you're going to have it added to your pre-sentence report, that's good. Then you have it provided 1 to 2 weeks before the interview. And if you have to, maybe make notes on a 5x8 card and bring that into the court with you if you're comfortable to be able to speak with the judge. If your attorney, after sentencing, it told you that you're going to have an appeal, or we're going to appeal this, the sentencing date, unless the attorney tells you different, the sentencing date still stands. And you can't assume that the lawyer has changed that or has handled that. I mean, nobody's got a crystal ball here. You don't want to assume that at all, because if there hasn't been anything written into the record, just because they told you that you have a case and that we think that, you probably will win at this particular appeal, where is right now, you've been giving a surrender date at a prison. And so back to the sentencing day, no attorney, no one can tell you what the Bureau of Prisons or the judge is going to do. Here's what we do know. We do know that the prosecutor wants jail time. Prosecutors eventually, at some point, you may either one, want to go into private practice, or two, go into politics. The judge, they're going to look at your pre-sentence report and they're going to use that to formulate who you are right immediately. And they get a recommendation from the probation officer. So this is why your initial meeting with your probation officer is critical. So having that meeting and providing all the information to the probation officer ahead of time is important, as well as having your narrative included into the pre-sentence report. Then, approximately 30 days before the sentencing hearing, you have the option, or you should be able to review your pre-sentence report and change anything that needs correcting. So we're going to review a case. I would say several weeks ago, this is a white collar case, and I got a call that he had a problem. He was facing some sort of charges, and we talked for a while, and I didn't hear from him for a couple of weeks. And then the other day, I heard from him, and essentially, he called me at nighttime or in the afternoon, and he had to report to prison the next day. Nuts. It's a scary place to be, so let's pull back the onion. He had changed attorneys and had confidence in the new one's great. And they were putting together to do an appeal. Problem is that I don't think they changed the surrender date with the court. And I stressed with him with preparation, but if he was anything like me, he probably was in just you hear things and you're not paying attention. And attorneys had left him with the feeling that everything would be okay and he would be free until the case was revisited. But the surrender date came and he was notified that he had to report the next day. So he had written a narrative, but it really wasn't reviewed. We don't know if how he had included the victims in it, character letters, his pre-sentence report. We were not able to review together, but he did recall that there was alcohol in it. But the judgment and commitment order that they had to go to a specific prison had no mention of alcohol or the drug program. And again, this is for federal. So that night they didn't know where to go. And the next morning, that night they called the marshal's office. The marshal's office didn't know. They called, like, we went online to the Federal Bureau of Prisons website, that nothing was there. The next morning they started driving to the prison that was suggested they go to, and they were told not to go there. It was the wrong prison. They had to go somewhere else. And so in a very short period of time, I did my best to bring them up to speed with the essentials of what they needed to know regarding the risk assessment survey on the federal side for first step back programs, visits, phone, how to send money, etc. Earned time credits, good time credits, and RDAP. But preparation is something that is the main reason that I exited, or my exit strategy from private practice into doing this, because I was not prepared. The other case was, and this was maybe a half a year ago, is that someone had been in prison for a long time. His significant other had contacted me and he needed to put together a release plan and had no idea how to do that. And so, again, I was able to send, if you will, templates of a release plan to that person. And this individual, ironically, had done a very good job on his own while he was incarcerated in reading books, getting educated, working, creating a small bank account, and he was sending money home. And so he was actually a star inmate, if you will. But the purpose of this is to find common ground, if you will, between federal and state cases. And I believe that the common ground is going to be, finding the right attorney for you, preparing the narrative, release plan, and then what's called the allocutioner, so that you could speak with your judge at your sentencing hearing. And then while you're in prison, spending time on personal growth and development, be it education, your GED, grad school, master's program, as much as you can learn, the staff will begin to take notice over time. And if you document everything that you do, which are other YouTubes that I have, eventually people will take notice. And there are those that have been given life sentences that have been able to walk free. I hope you guys found this helpful. And I thank you for taking the time to listen. I realize this has been lengthy, and I wish you all a good day.